Subscribe now and press the bell icon. Never miss an update.
Ready? 5 seconds. The appellant impugns the award of compensation on the following grounds: that there was no eyewitness to the accident which resulted in unfortunate amputation of the right arm of the victim, that injured Dharmendra is admittedly an illiterate person, therefore he could not have taken down the number of the offending vehicle, that since he was hit from behind by the offending vehicle and having fallen down violently, he could not possibly have seen or noted the number of the offending vehicle, that the complaint was made to the police one whole day later, and the evidence of the alleged pillion rider Shivcharan was found untrustworthy. Indeed, the claim of compensation preferred by Shivcharan has been dismissed, that the police complaint was filed on the basis of an intimation given by Deepak, who was told by the uncle of Shivcharan, who actually witnessed the accident. While the aforesaid arguments may look attractive at first instance, nevertheless, on examination, they are without basis. These issues have been dealt with by the learned tribunal as under: in an action founded on the principle of fault liability, the proof of rash and negligent driving of the offending vehicle is sine qua non. However, the standard of proof is not as strict as applied in criminal cases, and evidence is tested on the touchstone of principle of preponderance of probabilities. In order to establish the case, petitioner examined himself as PW4, being eyewitness of the accident. He deposed that on 12 February 2017 at about 5:30 p.m. he was coming to Bagpat, UP along with his friend for some work on his motorcycle, and when they reached near Mandola village, Tronika city, a truck bearing register number HR 55 W0193 came from behind at a high speed while being driven in rash and negligent manner and hit them, as a result of which they fell down and his right arm was crushed under the offending vehicle. Further, he deposed that he was shifted to nearby hospital, but due to his serious condition, he was referred to LNJP Hospital, Delhi, and during treatment, his right arm was amputated. It is observed that witness was cross-examined in detail by all the respondents. However, accident in question between the offending vehicle and motorcycle of petitioner has not been disputed. On behalf of respondent number 1 and 2, only a suggestion was given to PW1 that their motorcycle was being driven in rash and negligent manner and not the offending truck. Further, factum of accident has also been admitted by Vinod Kumar in his testimony. He has also mentioned in his cross-examination that he was informed by the driver after about half hour of the accident and he had not made any complaint regarding false implication of his vehicle. He also mentioned that driver had informed him that 2 persons were injured in the accident. It is further observed that technical inspection report PW4D also makes it clear that left side of the bumper of the offending vehicle got scratched in the accident. It is also not disputed that offending truck had hit the motorcycle from backside, though it has been alleged by respondent number 1 and 2 that the accident had happened due to rash and negligent driving of the motorcycle, but it has not explained as to how the motorcycle was responsible for accident. In view of above, it becomes clear that offending truck was being driven in rash and negligent manner and was responsible for the accident. Referring to the affidavit of the injured Dharmendra and his cross-examination, wherein he admits that the place where the accident happened was littered with gravel, Miss Raman, the learned counsel for the appellant, submits that it is therefore possible that the injured had fallen skidded on the gravel as a result of his driving at a high speed and thus injured himself grievously. Alternatively, he should have stopped and or slowed the vehicle down, which could have prevented the alleged accident by skidding. In either case, there would be contributory negligence by him and some of the awarded amount should be deducted. The said argument is untenable because gravel could be of any size. It does not necessarily mean that the person should stop his vehicle or that motorcycle cannot be driven on gravel. What was the size of the gravel, how far or how loosely it was littered? Was it so dangerous that the rider should have slowed down entirely? All these aspects are not in the realm of the present examination because it was for the insurance company to have brought evidence to show that the rider of the motorcycle was driving in a rash and negligent manner and thus contributed to the unfortunate debilitating accident. What is plausible is that because of the loose gravel, as a prudent driver, the injured may have slowed his vehicle down, which was then hit by the rashly driven offending insured vehicle.
Subscribe now and press the bell icon. Never miss an update.